Okay, good afternoon. My name is Ashley Leslie and I'm a Director in the Insolvency and Reconstruction Division here at Vincent's. Welcome everyone to our webinar, Update from the QBCC, Debt Recovery and Business Confidence in the Construction Industry. Before we start today though, I'd like to acknowledge the Jagera people and the Turrbal people as the traditional custodians of Meanjin, otherwise known as Brisbane, the lands on which our office is located and where we meet, work and learn. We pay our respects to Jagera and Turrbal elders past, present and emerging. We're fortunate today to have two experts joining us from the QBCC. The format we will follow is that each of the presenters will share with us their findings from their respective areas of expertise. There will be time for questions after each 15-minute presentation, and then we'll open the floor to questions and answers to be directed to any one of us. We start the session off today with the topic of minimum financial requirements, which will be presented by Natasha Dennis-Weller, Manager in the Financial Assessment Unit. I will now hand over to Natasha, who will introduce herself and present her topic.
Thank you. Thank you for the introduction and welcome everyone to another webinar for QBCC. As mentioned, I head up the team that deals with minimum financial requirements, and there's essentially three streams to that within our area. One deals with annual reporting lodgements, one deals with the financial assessment component of new licence applications or maximum revenue amendments, and the third one deals with financial audits or regulatory action in relation to those lodgements or information that we receive. But today I thought I would just run through some brief information in relation to the minimum financial requirements. So why do we have those? I believe that no other state does have the requirements that are imposed by QBCC. So the government of the day decided to reintroduce annual reporting information for licensees because there was essentially no visibility over our licensees' financial position for around about 6 years, since 2014. So it's essentially to ensure that the building industry remains financially sustainable so that we can get that information in a timely manner and that we can ensure that our licensees are remaining strong and viable. Who is required to report for minimum financial requirements? This one hasn't changed and not likely to change. Essentially anyone that deals with the public, so anyone that holds a contractor's licence to be able to carry out building work within Queensland. What are the minimum financial requirements? Everyone in this chat probably already knows what they are, but they cover the net tangible assets, the current ratio and the maximum revenue for a licensee through their financial statements that are provided to us. This is a common question. What's the difference between annual reporting and minimum financial requirements? They both fall under the same legislative piece, being the MFR regulation, but annual reporting, as it says, it's annual, and people may laugh at that, but we do get asked the question, how often do we need to provide this? It is annual, just FYI. It is just a quick financial health check of a licensee. It's usually based off their internal management accounts. Accounting standards don't need to be applied and aren't required to be provided for the bulk of our licensees being in category 1 to 3. And it is based on their most recent reporting year. So 30 June is most licensees' financial year, and we receive them by the end of December. It can be provided earlier. So they're usually up to 6 months old. The minimum financial requirements, on the other hand, is those signed financial statements or prescribed accounting standards to apply, and a minimum financial requirements report is only required in certain circumstances, and I'll take you through those of when they're required. So for an MFR report, we don't need that for annual reporting purposes. For an MFR report, it's usually if you want to upgrade or decrease your maximum revenue. It may also be if you're audited by the Commission, if you have a change to your business structure, or if you if you decrease your net tangible assets by 20 or 30%. So that's the only reason that we need an MFR report, and they can be provided at any time during the year. The financial information can't be any older than 4 months old that you provide the MFR report. Another interesting question that we get asked is the difference, what action we take in relation to non-lodgement. So the government is very serious about the requirement to lodge annual reporting. So licensees will get 2 reminders before the due date, 2 reminders after the due date, and then we move into regulatory action. So it is it is a serious requirement that licensees do lodge that information by the due date. Otherwise, unfortunately, they may end up being cancelled for not lodging. What we do with the information, though, on the other hand, is a different matter. So if that information shows that a licensee may not meet the requirements, QBCC as a risk-based regulator always has been, potentially always will be. So we assess that information and see whether there is a risk to the industry. If there is a risk, if the licensee is trading outside of its turnover or is conducting a lot of turnover, and the breach of the minimum financial requirements is substantial, then it's likely that we may take some regulatory action for that licensee to resolve that position. If the risk is low, they're a smaller category, they don't have much trade creditors at risk, then it may be likely that we let them know that they may not meet the requirements, but that we are taking no action at this time. So that the action that QBCC takes in relation to non-lodgement is a totally separate piece to the action that we may take in relation to whether they meet the requirements or not based on that information. Trust structures has been and probably always will be a pain point for both QBCC and the accounting industry. The intent behind the minimum financial requirements, as I said, is to ensure that a licensee is financially sustainable. It's to ensure that a licensee has the financial position to cope with a downturn or to cope with not being paid off a job. That's the reason that QBCC doesn't license trusts. So the trust protects those assets. The assets are protected from creditors. Someone can't sue the trust. It's not a legal entity in its own right. So that flies in the face of the minimum financial requirements, where we are trying to ensure that the licensee is financially sustainable. So as I said, we don't license trusts. All of the assets need to be held in the Pty Ltd or the trustee entity. And if they're not, then the licensee needs to rely on a deed of covenant and assurance, usually from a director, which again is probably not the intent of forming a trust to start off with. The trust is there to protect those assets. So it doesn't really make sense that you're protecting assets in the trust, but the director then has to trump up his own property to enable that license to continue. So with the change of the MFR regulation, the biggest change that was in relation to trusts is that the trust gets assessed under the same framework as the trustee. So any intangibles within the trust, any borrowing costs, any debtors that are outside 365 days or between 180 and 365 days have to get deducted. If that means that the trust flows into a negative position, that will then mean that that negative position of the trust flows back to the trustee, and that means the trustee may fail for that reason. The net tangible assets is based only on the trustee. So if it's a paid up capital only company, $2 or $10, that would be the NTA of that licensee. And again, they may need to rely on a deed from a director or an associated company. The current ratio, however, is assessed on both the trust and the trustee's current assets and current liabilities. This is the last slide that I did have, I think, from memory. But we do commonly see a number of financial statements being provided to QBCC, and these are usually after QBCC relays or raises some concerns in relation to the first set of financials. So we may say we've applied the MFR regulation over the top of your financial statements. We've had to deduct some things that are in the regulation that may lead to the licensee not meeting the financial requirements. And then we get a second set of financial statements for the same reporting date, which may have changed some figures to alleviate those concerns. They may show new concerns though. We then may get a third set or a fourth set or a fifth set of financial statements for the same reporting period. That really raises concerns for us because the information that you provide is meant to be a true and fair position of that licensee. It's not to alleviate those concerns by amending those financial statements. There is a way to amend financial statements under the accounting standards, either 108 or 110. If it's something has come to your attention through preparing those financial statements, and that's not usually concerns raised by QBCC. So we don't like to see a second set, a third set, a fourth set for the same reporting day because we are trying to work out the true financial position of that licensee. That's it for my presentation. I think I might have been slotted for 15 minutes and I think I may have captured in about 8 to 10. So very quick, but happy to take any questions if there are some. If not, I was just going to touch on the small business restructuring proposals that are starting to be rolled out through the government. So out of around about the 600 that we've seen through ASIC so far, only 8 have been QBCC licensees, and out of those 8, only 4 are current licensees. My assumption is the threshold to do the restructuring proposal probably doesn't sit with most of our licensees. They're usually likely to have creditors over $1 million. But as I said, we've only got 4 that we have been aware of so far, and we do monitor those notifications every day. What we're doing with that is just to ensure that the proposal is accepted by all creditors. So to get the proposal across the line, all creditors have to accept it. We'll continue to monitor that until those creditors have signed off, and then we'll continue to monitor that licensee to ensure that the proposal is successful. So that's our current stance on those. As I said, we've really only seen 4 out of the 600 or so that have come through, so it hasn't had a large effect so far on the building industry in Queensland. I'm happy to take any questions though.
There's none in the chat box at the minute, but so if anyone does have a question, feel free to drop that in the chat box. But in the meantime, I just thought I'd ask Natasha, what are some of the most common areas that you see when companies report their annual reporting, either themselves or through their accountant?
Okay, great question. Aside from not needing an MFR report for annual reporting, that's a common one. We definitely don't, unless you want to upgrade or downgrade. The other one is assuming that your annual reporting information will change your maximum revenue. It doesn't. An MFR report will. So those two things don't sit neatly together. Probably the main one would be the misconception that you only need to report a licensee's Queensland construction income. It's not. It's the whole income for that entity. And the reason for that is if you've got a building company in Queensland and that entity, so that PTY Ltd also does building work in Victoria, and the Victorian part of that building business is failing, then that may affect the Queensland creditors for that building entity. So it's the whole total income of that PTY Ltd, regardless if it's in Queensland, regardless if it's building construction industry income.
Great. And then are there any pearls of wisdom that you can give the people logging in today who might be about to lodge their annual reporting data? Any tips, tricks they should look out for?
Yes. So don't leave it till the last minute because systems can fail or go offline. So don't leave it until the 31st of December if you've got the information ready to go. Make sure that your licensee has done the process to make you an authorised representative to be able to lodge that information. And there are different sections within the licensee's area to authorise people to do different things with that licence. So make sure you are an authorised representative, and make sure, if you can, that the licensee's details are up to date. So that licensee will receive emails, as I said, prior to the annual reporting day and after the annual reporting day. If their email address isn't up to date, they won't receive those notifications. So it's pretty helpful if they do make sure that their details are up to date with us.
Yeah, no, that does sound very, very important. Details up to date. Excellent. Okay, well, there's no other questions at the moment. I do note there are other speaker has dropped off of the... are you back now? There she is, just in time. Perfect. Okay, but if you do have any questions as you go through that you've thought of, just drop them in the chat box. We can even double back to Natasha at the end if it's applicable to her area. Otherwise, for now, we will move on to our next speaker, who is Rebecca Ross. She's a Principal Manager, Forensic Accounting and Exclusions in the Financial Compliance Branch. So Rebecca will be taking the topic of construction industry insolvencies and excluded individual companies. So over to you, Rebecca.
Great, thanks Ashley, and thanks to everyone for attending. So as Ashley mentioned, I'm the QBCC's forensic accountant. I also manage the exclusions team, and that's the team responsible for administering the sections of the QBCC Act that take effect when one of our licensees becomes insolvent. This would apply to both companies and individual licensees. I'd like to take you through some materials, as Ashley mentioned, I've prepared. I hope you'll find them interesting. They touch on what we're seeing in the industry at the moment with Queensland builders, and also providing a little bit more information about the exclusion legislation itself. Great. So the first slide here, it outlines the number of QBCC current or former licensees who have become insolvent. Now, when I say former, I'm talking about licensees going back 3 years, so not licensees who we haven't had as a licensee in more than 3 years. So as you can see, back in fiscal 2019, we had 248 insolvencies, a lot higher than present. That was an average of about 15 per month. 21 per month. This decreased in fiscal 2020 and again in fiscal 2021. This is obviously when the COVID pandemic hit in January of 2021. And then we had the government stimulus package, which significantly impacted, lowered the rate of insolvency. This year, we've got in the quarter one, we had 45. Now October, we had 17. So we're seeing still a trend of increasing insolvencies. And if we continue on this trend, I'd expect to see about 180 insolvencies by the end of the year, which is as high as it was back in 2019. But hopefully, of course, this trend does not continue. Next slide. It's just a graphical representation of the same. And as you can see in October, I've left that out because we just got our monthly reporting done, but that is now up to 17. All right, an overview. Just some of the key factors here that we've all been hearing and seeing about the insolvency in the construction industry. So we had an almost 50% increase year over year in 2022. We know that the government stimulus package created a housing boom. That was the main catalyst, being the home builder scheme and low interest rates. Demand for new housing came just when the supply chain blockages occurred. The flooding in Eastern Australia caused increases in construction and labour costs, as well as the war in Ukraine with the energy price increases. Notifications of new insolvency appointments this year, as I said, are trending not significantly higher, but they're still on the rise, but still below historic levels going back to 2019. I've provided for you here a few. It's a little bit small, so hopefully you can see. But these will be distributed, these slides. We have Lansky, Oracle, Pivotal, Condev, High-Tech Glazing, ProBuild. Some of these are very large, but predominantly residential builders, until just recently Lansky being one of our first predominantly commercial builders. That was category 5, and that was this month, as you may know. Great. This one I find quite interesting, what it calculates here, but first noting that Queensland represents 19% of construction businesses nationally. And what we've calculated here are the share of the national insolvencies. And it is interesting to see that for 2018 and 2019, it's bang on 19, which is what you would expect if the economic factors were the same across the nation. We do see a slight change, but just slightly down to 18% in 2020. And in 2021, it's down to 13, a significant drop. I note that the COVID pandemic caused lockdowns that were more severe in other states, New South Wales and Victoria. And as our industry continued to trade at near normal levels, that's probably why we represent a significantly lower percentage of the national insolvencies. I put flood question mark impacts because I don't really see it there. Those numbers are quite all over the place. But right now we're down to 17% annually. Well, we're 12% in the first quarter. Here's just, I think, one last chart for you on insolvency in the industry in Queensland. We've calculated at the top the number of licensees, the number of licensee insolvencies per financial category over the total licensee population, i.e. to calculate the likelihood of insolvency. Now, I'll apologize that these are figures from 2019 and 2020. So we're in the process of updating and having a look at 2021 and 2022. But not terribly consistent overall, but there are some interesting observations in that less than 1% of the SC1, SC2, and Category 1 licensees, almost, it's a slight over 1%, under 1% of those categories, we saw an insolvency event. For Cat 2 and above, it's a more significant likelihood of insolvency. However, one thing to keep in mind is that predominantly our figures we have far more licensees in SC1, SC2, Cat 1 and Cat 2 we've got, and these are older figures, but 2,000 SC1, 8,000 SC2, 4,000 Cat 1, 4,000 Cat 2, but when you get to Cat 4 to 6, we're talking 100 to 200 companies. And so when we look at the actual number of insolvencies, there are more obviously in the SC1, SC2, Cat 1s, it's just proportion. All right, and then down below, what we've calculated here is the average total amount owed to creditors. So we've pulled up the creditor reports, and we didn't do review every single creditor report. We picked, I believe it was a population of about 70 odd across those years, and we calculated the amount owed to creditors, and then put it on a graphical representation. This would be SC1, SC2 to 5. Didn't fit on one chart without making any sense. So this is 6 and 7. Now 7 does look far disproportionately greater, but this was the year that RCR Tomlinson became insolvent, and that did skew the chart a little bit because not every SC7 would be quite so big as RCR, though there are others. So that's just for those who are interested. I can pause there to take any initial questions on that aspect because I'm going to move to the legislation.
There's no questions coming through at the minute. Doing a great job.
Thanks. Great. So the purpose of the exclusion legislation is to ensure public confidence in the QBCC's licensing system. And the provisions are there to prevent those responsible from poor financial management from running a business in the industry. Yeah, so the legislative provisions under the QBCC Act, Section 56AC, set out that QBCC will exclude an individual, which means prevent them from holding a license, where they become bankrupt or enter a Part 9 or 10 agreement, or are responsible for a company failure. Company failure is defined under the Act as where a provisional liquidator, administrator, or controller is appointed, or is wound up, or ordered to be wound up, and is for the benefit of creditors. This applies to persons who are directors, secretaries, or influential persons for a construction company at any time or within 2 years of the appointment. The duration of the exclusion is a period of 3 years from the date of insolvency. For this period, what it means is that you can't hold a QBCC contractor or nominee supervisor license or be in partnership with a QBCC licensee. You can be an employee of a construction company as long as you're not influential. A person involved in 2 separate insolvency events may face life exclusion. They become a permanently excluded individual. Under what circumstances will a company become an excluded company? That's when a company becomes, that is when an excluded individual is a director, secretary, or influential for a company. The effect of being an excluded company: the license will be canceled. They'll be unable to reapply for another license until the exclusion period ends, unless the person who is excluded ceases to be a director, secretary, or influential. Definition of a construction company under the Act: it's a company that directly or indirectly carries out building work or building work services currently or within the prior 2 years. Definition of an influential person: that's a person who is in a position to control or substantially influence the company's conduct. Now, the legislation says that a company may be influential, a person may be influential for a company if the person is a chief executive officer or general manager, holds or controls 50% or more of the shares, gives instructions to another officer, makes decisions that affect the whole or substantial part of the company's business or financial standing, or makes representations that would cause someone else to reasonably believe that person controls or substantially influences the company's business. At QBCC, our experience in the courts is that influential person can be hard to prove. We've had cases where we thought we had far enough evidence of these factors being in place, and still these decisions were overturned. So as a consequence, we are a little bit cautious when we decide to take action on influential. Rights of review. So some of our decisions are reviewable decisions. This gives the individual the right to have the decision internally reviewed by QBCC in an independent office of QBCC, or they can go to QCAT, the Queensland Civil and Administrative Tribunal, and have their case heard. Not all decisions not all factors here are reviewable. The rights here are on the notice of reasons for proposed cancellation or suspension and the decision notice for a licensee. Non-licensees, the review rights are on the decision notice only. There are some submissions that you can make when we send you a notice of reasons for proposed cancellation under the exclusion legislation. One of these is for a permanent exclusion. Again, reminding you that permanent exclusion is when there's been 2 events, and what the legislation says that if these 2 events are consequences flowing from what is in substance one set of circumstances, then you do not become a permanently excluded individual. So the onus is on the individual to satisfy the commission that those events are consequence of the same set of circumstances. I was going to give you an example. The example would be when a director is guaranteed the debts of a company, and the company fails, and then those debts of the personally guaranteed debts are called, and then the director becomes bankrupt himself. The onus is on the individual to satisfy the commission that both events are consequences. There's my example there. The other submission, one other submission we get is submissions as to solvency. 56 AC4 of the QBCC Act provides that an individual is not an excluded individual if they can satisfy the commission that at the time that individual ceased as director, secretary, or influential, the company was solvent. We get other submissions. Some we consider all, but some rarely would ever be accepted. Others we of course would. So not a construction company. Where we see a submission get through on this is when the company has not been trading or engaged in any construction or construction services in the last 2 years. Not for the benefit of creditors is a submission we have seen from time to time. However, in the courts, it has generally been found that this is not supportable, and we generally would not support it. The basis is in the slide here that there is a benefit, established by the court, there is a benefit to creditors regardless, even in the circumstance where the creditors will in fact be paid in full. We do get submissions essentially stating it wasn't my fault, the bankruptcy or the appointment of administrators to a company. They'll say that it was the economic climate, disputes, severe medical or personal events. Unfortunately, these are rejected outright because the legislation is not discretionary. So in this instance, all we can do is remind them that there are still options to work in the industry as an employee if they can find work. It can be hard for them to find work after an insolvency event and exclusion, but it's possible. And also the period of exclusion is 3 years unless it's permanent exclusion. Here's a bit of further information with respect to solvency. And I put it in here because it's relevant if you or one of your clients wishes to send in a 56AC4 submission. What we would consider a good submission would consider, firstly, here the definition of insolvency under the Corporations Act, and then the rule of law, the cash flow test, and then the other indicators of insolvency that have been established through common law. And that's just further indicators of insolvency established through common law. And Natasha already touched on this, so there's not too much more I can say. I believe she already indicated we've had very few. I think she said 4 or 8, but 4 were non-licensees, so 4 were licensees. And from my part in the exclusions team, we do not take exclusion action. We notify Natasha's team in the financial assessment unit. And that's all from my presentation, but I'm happy to take some questions as well.
Okay, well, for the benefit of those who mightn't be keeping an eye on the chat box, there was a question earlier in relation to whether the appointment of a small business restructuring practitioner would be considered an insolvency event or a company failure. And Natasha has responded to that, advising that no, small business restructuring is not considered to be an insolvency event when it comes to whether it fits into the definition of a company failure. So thank you for that question. There is another question here too, and it's from Michael. Is the QBCC willing to fund the appointee to assist in taking proceedings to overcome asset stripping or phoenixing?
That would be Rebecca.
Yeah, that would be my area, but no, I don't think so. And I'd probably have to take that back to upper levels of management. As I said, I'm the forensic accountant and I manage the exclusions team in terms of like applying the legislation, but that's more of a administrative question, so I can take that on board, but I believe the answer would be no unless we were a creditor, and that's a different can of worms.
Yeah, there's no formal application process an appointee can make like there would be, say, under ASIC, for example, for funding. Okay. I'll just refer, there was somebody who wanted, I think, if Joel is still online, I will just allow you to speak if you wanted to still ask your question. No, Joel? Okay, well, that's all right. And just generally, have you spoken with your counterparts in other states about how their members are faring and how they might compete or be faring against the Queensland industry?
So with respect to insolvency, we've looked at this slide with respect to our share of insolvency. With respect to correspondence, we have a couple of, we do so. In one regard, we're a member of the anti-phoenixing task force, which we sit on along with, I can't remember them all, but definitely the Victoria Building Authority, New South Wales, the ATO and others. And it is predominantly anti-phoenixing, but it's also just insolvency concerns generally. I would say that the concerns raised are very similar and the issues faced are very similar, except of course we had slightly different factors at play when there was floods and fires and that sort of thing.
Yeah, great, thank you. Another question here, is it possible to get some commentary on the changes to general financial statement reporting? Is there likely any changes to legislation for smaller businesses?
I'll take that one, and I apologise, Simon. I should have addressed that because it is a very popular topic at the moment. So unfortunately, or fortunately, whichever way you want to look at it, the removal of special purpose financial reports is outside of QBCC's control. That was done through the Australian Accounting Standards Board. The legislation that QBCC has states that signed financial statements must meet the accounting standards. That forms part of the accounting standards. So our legislation gets wrapped up within that. So for annual reporting requirements for the bulk of licensees, the change won't have any effect because you can still provide internal management accounts, which don't need to have accounting standards applied to them. If you are completing an MFR report for a financial period after 30 June 2022, unfortunately, it will need to be general purpose financial statements or financial reports. QBCC doesn't have a discretion over that, and we also don't have a discretion on applying the legislation. So to get the legislation changed, you would either need to go through your accounting bodies or go to Department of Energy and Public Works. So QBCC doesn't write the legislation, we enforce the law. So that's our role. As I said, it's a circumstance that's outside of QBCC's control.
Great, thanks, Natasha. Rebecca, just another question for you. You mentioned during your presentation that in the case where there's been two separate insolvency events that may result in life exclusion for that particular individual, would that be the two separate insolvency events? Could that be two entities in the one group, or do they need to be completely separate from each other?
Yeah, that's a good question. So certainly the 56 AC5 might apply if that was the case, if it was two companies within the same group.
Okay.
It depends on the individual circumstances, though, of course.
Sure. So it's not a necessary definite result. It'll depend on the review. Great. Okay. Okay. Joel, are you there this time? No. If you do have a question, maybe pop it in the chat box. It might be a bit easier than trying to connect here. Okay, there's another question just come through. Are you able to outline the new trust account requirements for larger companies? Is there a requirement for a trust account if the project is greater than $1 million each?
So I can answer that not to a great degree. It's outside of the scope of my expertise, but I do know that you do require a trust account for projects over $1 million, but there are certain restrictions to that. So it hasn't hit the residential area yet. I believe that it is for commercial work, including duplexes, shared walls, things like that. I think Joel might be back online again, if it's the same Joel.
Yeah. Joel, are you there? No. Okay, no worries. Okay, well, if there's no further questions for now, I just wanted to touch on a related topic. I am a mental health first aid officer, and I think I feel it's important just to take a moment to talk about mental health in the construction industry. I recently saw some staggering statistics around mental health, that men in the construction industry are 53% more likely to die by suicide than other employed males in Australia, which equates to more than 190 construction workers every year. According to figures from the University of Melbourne and Deakin University, a construction worker is lost to suicide every second day, and that's just simply devastating. And some we need to really have that known and be trying to tackle that head on. It's an industry that's so highly regulated for health and safety aspects, but death by suicide is 6 times more higher than death due to site accidents. And it's thought that in more than 90% of the cases, the individuals concerned didn't seek professional help. Either they didn't want to, they didn't know where to find it, or they weren't encouraged to seek it. So a question for either of you, does the QBCC have anywhere that they send their members to for mental health assistance?
Yes, we do. We have mates in construction that deal with our licensees, which is the first body that we would refer to if a licensee is struggling with any issues within the building industry, and that's totally understandable at the moment given the pressures that builders are currently facing. So we would definitely refer them to that organisation.
Excellent. I noticed too that there's recently been an announcement that national construction firm B6 Watpac, and together with Australia's first accredited and Indigenous-owned mental health organisation, Goanna Academy, founded by Greg Inglis, have formed a 12-month partnership to break the silence on mental health for construction workers, Indigenous people and young men. The CEO of B6 Watpac, Mark Baker, has said that the partnership of these two organisations not only gives workers the resources and channels to speak up, but also a reason to shake the stigma and be a role model to show the way. I just wanted to shout out another fantastic organisation doing its part to reduce the stigma of mental health issues in construction is TradeMut. Now, some of you may know TradeMut is an Australian workwear brand that aims to make tradies and workers of all kinds look and feel great at work, and in doing so, reduce the rate of suicide in the construction industry. You might have seen their signature loud and vibrant shirts as you pass by some building sites. I've certainly seen them in increasing numbers of late. And those shirts, if you've seen them, they're certainly a conversation starter. Speaking of conversation starters, construction employers, employees and their families can call or text "This is a Conversation Starter" or TIACS on 0488 846 988 for free professional mental health support. So that is very important if you do know of someone, or you have yourself got some mental health concerns that you'd like to speak to someone about. Please reach out and talk to someone and get on track to get your mental health back on track. For those who might want to contact mates in construction that were mentioned by Natasha just recently, they can be contacted on 1300 642 111. So very important you reach out to somebody for some help if you need it. Now, there was another question here. I'll just read it for the benefit of those who aren't watching it. The question was, Natasha, can you clarify the general purpose financial reporting for categories 1 to 7 GPFR are required? For annual reporting license categories 4 to 7, management accounts are SPFR are okay to provide. And the response was for an MFR report for financials post 30 June 2022. It would be the GPFS for categories 1 to 7. For annual reporting in categories 4 to 7, they are required to provide signed financial statements, not management accounts. So that was touched on earlier in the presentation. So feel free to check in with the recording. We'll make that available after the end of the session too, for those who might have tuned a bit after we started today. Okay, is there any other questions that anybody would like to ask any of the three of us today? No? Okay. That brings us to the end of the session today. I would like to thank both my panelists for bringing their expertise to our audience and being so committed to updating the professional services in helping their construction clients. As I mentioned, today's session has been recorded, so it will be available to access shortly after the session closes today. If there are any other questions that you mightn't have thought of that you want to raise later, please feel free to email them through. My email address is on the screen, and I can direct them to the most relevant person to get you a response personally. Or you can give me a call here at Vincent's, and we can have a chat through your situation. Otherwise, if there's no further last-minute questions, I'd like to thank everybody for attending today, and I hope you have a great day. Thanks very much.
Thank you for having us.
Thank you.